Welcome to the Commentary Magazine Daily Podcast. Today is Tuesday, April 8th, 2025. I am John Podhoretz, the editor of Commentary Magazine. With me, as always, executive editor Abe Greenwald. Hi, Abe.
Hi, John.
Senior editor Seth Mandel. Hi, Seth.
Hi, John.
And senior fellow at the American Enterprise Institute and our old friend Adam White. Hi, Adam.
Hi, John.
Because neither Christine nor Matt is on, we, of course, are obliged by law. It's actually, I believe, the 29th Amendment to the Constitution of the United States that someone from AEI must be on the Commentary Magazine podcast. And so Adam has kindly agreed to fit the bill so that we do not find ourselves in a constitutional crisis. We are going to discuss questions relating to possible constitutional crises in a minute. But before we do that, of course, Prime Minister Benjamin Netanyahu was in Washington yesterday for meetings in the White House and in the Oval Office with a spray with Donald Trump in the afternoon. And I think it is fair to say that, as Jewish Insider puts it this morning, he came away with nothing. He got nothing. He came, I don't know what he wanted. I don't know why Trump wanted him here, but he came to see if he could do something about the tariffs. He got nothing on the tariffs. He may have come to talk about doing something with Iran. He doesn't seem to have come up with anything on Iran except being told in his presence that the United States has decided to launch what the president referred to as direct talks with Iran. Now, direct talks with Iran have not taken place between America and Iran, I believe, in 9 years. I mean, there haven't been direct, formal, high-level talks since 2015, 2016. I don't think the Biden people actually did anything that could be constitutional called direct talks. So that would leave John Kerry negotiating as Secretary of State for Barack Obama with, help me out, Seth, with the guy, the Iranian foreign minister. Can you
everyone loved.
You remember his name? I can't. No one remembers his name.
I'm blanking
He's the
on him
Iranian
too.
foreign minister.
Oh my God,
it's bad. I can't remember his name. Anyway, how art the mighty fallen? How brain cells die as you approach your 64th birthday? Nonetheless, Seth and Abe, you are both too young to be having the same problem that I'm having. Anyway, Iranian foreign minister and John Kerry negotiating together to create the, of course, horror that was
Zarif.
Oh, but you looked it up.
Yeah, it was killing me.
Zarif, thank you. Okay. Anyway, so we're now going to have direct talks at a very high level. Apparently, that high level is Steve Witkoff, which is to say high level the way that QVC is a high level television channel. It's high level because Trump seems to like Witkoff. It's low level because Witkoff is a low level, fourth rate joke. But nonetheless, here we are going to be having negotiations with Iran over God knows what. Trump wrote the Ayatollah a letter. The Ayatollah said, I will destroy you and kill every Jew and blow up the planet. And we're still having direct talks with them. Maybe it's a last warning before we give Israel the green light to do something. Maybe it's a last warning before we join in Israel doing something. Kind of doubt it. Didn't sound like that was where Trump was headed based on what he said. But of course, what Trump says and what he means can be two different things. So I said yesterday, maybe this is all about Iran. I was wrong. So congratulations to me for being wrong. I'm admitting that I'm wrong. And my hope that maybe he would wag the dog to avoid the topic of tariffs was, like all such pop culture inspired hopes, foolish. So, what do we have to say about this, Abe?
Well, I didn't think it was as. I mean, he did. Look, he said we're going to talk to Iran, very high level. Can't tell you any more than that. And then he was asked directly if the Iranians don't agree to a deal, whatever that means, would you attack or support an Israeli attack on them? And he said something like, well, I'll just say that if they say no, Iran's in a lot of danger. So it was one of those Trumpy you'll be in hell, vague things. Which, look, he's told that to a lot of people who still aren't in hell. So
Well, better that, I suppose, than not saying you're
Right.
in hell if you're dealing with Iran, I
Yes, I'm
suppose.
saying he was backing it up with something.
Right. And I should say, when I say that Bibi got nothing, it is actually not fair to say that Bibi. It is very meaningful in the world context, even in 2025, even with the change in government, all of that, for the American president to have the Israeli prime minister in his office saying, "We are with you. We are with Israel." Like we are the only country in the world aside from Argentina and Czechia, which moved its embassy to Jerusalem this weekend, and Hungary, which moved its embassy to Jerusalem. Like there are like three countries in the world that are willing to say that they stand with Israel. The United States is the fourth. It doesn't mean nothing, and I shouldn't poo-poo it. It means a lot. And this weird world in which we keep being told by people like Michael Roth of Wesleyan and Yair Rosenberg of Moronhood that it's really terrible that Trump is so philo-Semitic, because he isn't really. He's anti-Semitic, and Jews shouldn't fall for it, because just because he's fighting for Jews on campuses doesn't mean that he's not terrible. Since Michael Roth has done absolutely nothing to fight for Jews on his own campus, attacking somebody else who is actually trying to do something to fight for Jews on campuses is yet another mark of his unspeakable leadership of his and his intellectual and solipsistic disgrace. Nonetheless, so I'm not saying it's nothing. So I wanted to take back my nothing. Seth?
Yeah, I saw a video of Donald Trump pulling the chair out for Bibi to sit down on and then pushing it in. And I was thinking to myself, that's reason enough to come to America, to have Donald Trump pull a chair out for you and push it in as you sit down, like you're sitting down at a fancy restaurant. I don't I don't know what's going on, what they even mean by the direct talks exactly, but the problem is less about what Trump will accept and more about the time waste, because there's a window now where, as Jonathan Shanzer says when he comes on the podcast, the skies above Iran are naked, is the phrase that he always uses. There's a window where it would, the U.S. could, if it needed to, dispense with Iran's nuclear program, half asleep, sleepwalking in the middle of the night. They could do it. There's literally nothing blocking them. That changes and everything changes. So I think, Trump is being pulled in a couple of different directions here because he likes deals and he wants peace and he wants to be the deal guy. But you can actually, it can be a mistake, a genuine mistake, to have talks for the sake of having talks if the clock is going to run out on a particular opportunity.
So that's where we are in relation to this question. I do think that we are in a very bizarre circumstance in which we have a Secretary of State of the United States who appears not to be negotiating for the United States on anything. And then there's this New York real estate guy who is going around the plan. Now, if that's what the president wants, that's what the president wants. I hope Marco Rubio likes, I mean, he's working on immigration, ordinarily not really a huge issue for Secretary of State. And there is a lot of brass and silver on the seventh floor of Foggy Bottom that needs to be polished, and maybe he's doing that. But really, one might want to activate one's diplomats to do the diplomatic negotiating. But it's just me. I don't know. I mean, if you're going to have them, you might as well use them. But that gets to our friend Adam White, our constitutional scholar, our legal expert, our friend, Supreme Court whisperer.
Yeah.
Supreme Court did a big thing last night, 5-4 decision that froze, that essentially said, no, you don't have to return anybody from El Salvador yet. Don't have to do it. I don't care what the judges, the lower court judges said you needed to, you don't need to. So it seems big, and it was a split decision. However, it's less big because of the reasons, right, Adam? Mm-hmm. And then B, there is an important, what appears to be 9-0. I wouldn't call it concession, but step going forward, represented by the one agreement that all 9 justices seem to have had in this case. So, can we talk about what the procedural thing was, and then what the consensus was of the Supreme Court going forward with these cases?
Absolutely, John. And can I start on a philosophical note?
Please.
About 200 years ago, Tocqueville's writing about the American judicial system, and he says, in America, there's scarcely a political issue that doesn't sooner or later become a judicial case. And so it's a timeless point. But today, if he were writing that, he might cut out "or later," right? It's sooner or later ain't what it used to be. And what we're seeing right now, and this latest Supreme Court order is a reflection of that. We're seeing this constant foot race between an administration that wants to make and implement wild changes in policy, or dramatic changes in policy as fast as possible. Trial lawyers who want to outrun that and get to court, pick their judge, pick their court, try to get a TRO before the administration can act. The trial judges who, once they get the cases, want to move as quickly as they can to stop as much as they can. And then while all that's happening, back to the administration, which is doing its best to almost Dukes of Hazzard style, outrun the law before the courts can catch up with them. And so this Supreme Court order last night, the short opinion, is the latest effort by the Supreme Court to try to impose some kind of structure and process and proper pace on the administration and the lower courts. But within the court, you have the dissenting justices like Sotomayor and Kagan and Jackson complaining that now it's the Supreme Court that's moving too fast. And so that's sort of overall what's happening right now. Now, can I get into your actual question?
Can we talk about the moving too fast? Because I think just to flesh this out.
Yeah.
So administration began, we're not even 3 months into the administration. It's April, right? So we're almost 3 months into the administration.
Mm-hmm.
And the courts are, there are dozens, I think now, literally, of court cases dealing with all these aspects of DOGE and immigration and this and that and the other thing. And the decision yesterday was on a specific matter to deal with this one controversy regarding the deportation of the accused Tren de Aragua people to El Salvador. And what the court said was the lower courts moved too fast, or have made too definitive a ruling that the jurisdiction is a problem, right? The jurisdiction is a problem, and so jurisdiction needs to be resolved before we can move forward. And then the liberal justices are saying, why are we getting involved here? Let the lower courts work, and then we'll rule on the controversy. We don't need to intervene. We can rule on the controversy in due course.
Right. This is Judge Borsberg in D.C., his famous order from a little less than a month ago, trying to stop the deportation of these Venezuelans to the South Salvadorian hellhole as the planes were loading up and taking off. And quite frankly, while I'm not the president of the Justice Sotomayor fan club on this podcast, her opinion in this set of opinions that came out last night does a nice job of the sort of tick-tock, play-by-play, how things were playing out. But the basic point, as you said, is this. The Supreme Court said the plaintiffs filed in the wrong court. They raced to get all of their cases in front of Judge Borsberg in D.C., but what they really should have done is they should have filed their cases in the district courts where the individual prisoners were being held, whether it's in Texas or elsewhere. The court said that's required because these are basically habeas corpus cases. The plaintiffs styled this as more of a class action lawsuit under the Administrative Procedure Act and other things, and of course challenging the use of the Alien Enemies Act. But the court majority in this short opinion last night said these are basically habeas corpus cases, and the right place to file that case is where the plaintiff, the prisoner, the detainee is being held. So you can't pick your judge willy-nilly. You can't pick your court willy-nilly. You have to go refile this case in the original, in the proper venue. That will take these cases away from Judge Borsberg, I think to the dismay of many who really rallied behind his order on the bench that they needed to turn the planes around as they were taking off. Who knows how the lower courts in Texas and elsewhere will rule? The Fifth Circuit seems more hospitable to the Trump administration's view of the law than the DC Circuit is.
That's the circuit in Texas.
Yeah, that's right. But the dissents in this case, which Justice Barrett joined for one very small part, they said the court is deciding too much too quickly. That the Supreme Court is ruling on this habeas corpus thing, this saying these are really habeas cases. But that's not really a clearly settled area of law. The court should have slowed down, gotten more briefing on that. And also, the dissenters said, this is not the stage at which the Supreme Court is supposed to intervene. This is just a temporary restraining order from the district court in D.C. It's going to expire in a couple of days. The court should have waited for things to play out properly in that trial court. To which the majority responds, no. This is not really just a little TRO. This is, in essence, something different called a preliminary injunction, which the Supreme Court can definitely weigh in on. Again, it gets down to the Supreme Court trying to impose some real order and some realistic sense of what's happening in the district courts, and not just allow the plaintiffs' lawyers and a bunch of random trial judges in D.C. or California or Rhode Island or whatever.
Rhode Island, yeah.
To just single-handedly take over federal policymaking indefinitely. It's the second time in about a week the Supreme Court's issued an order like this, and I don't know that it'll be the last.
Okay, so I want to ask about disingenuousness, because I see the possibility of saying that both sides in this matter are being disingenuous, that they've lined up, except, as you say, for Barrett. And Barrett's becoming a more interesting justice by the day, as far as I can tell, in terms of her interests, her procedural interests, and the underrating of her potential ideological or juridical independence over the course of her career. But you have on the one hand this ruling, which is, we're going to stop this, but we're stopping it because it was filed in the wrong court.
Mm-hmm.
Is that really why they're stopping it? Or are they stopping it because they're attempting to slow down the coming of the potential constitutional crisis? So that would be disingenuousness, number one. Classic, as Seth, a student of the Talmud, would say, it's a classic Talmudic dispute where one judge, one person could say to the other, you're full of it. That's a factitious reason you're giving. You just want the end. You want the end that you want, and you're coming up with whatever argument you can come up with to provide the means to that end. And the same could be said in reverse for the dissenters who are saying, no, we need to slow down. This isn't the way we do things here at the Supreme Court. Like, they're so concerned with process and doing things in the right way and making sure that the process of the Supreme Court is followed adequately. There is, as far as I can tell, one justice and one justice alone who is really consumed with that issue for the most part, and that's Roberts, the Chief Justice. But does one really have to take Ketanji Brown Jackson seriously when she says this isn't the right way to deal with a controversy or an emergent? Like, it's not even really an emergent. Let it go. Let it ride. If the shoe were on the other foot and something else were happening, she could just as easily be on the other side. So that would be my. Do you agree with this analysis, or am I being cynical and unfair to both sides?
Oh, John, you'd never be cynical or unfair. I'd say I don't know that I want to cast aspersions on either side here. What I'll say is each side makes a good point, and I suppose they've settled on their point for reasons of their own. I mean, there's a great line that Kagan, she used in a dissent last week in another one of these cases involving a lower court's attempt to freeze Doge spending cuts, and the Supreme Court, vacated that district court order. Now I can't find the line in front of me, but it's in Sotomayor quoted it last night. She said the court is proceeding quickly on bare bones briefing, no argument, and scarce time for reflection. And frankly, like sort of the classic sense of the Supreme Court's work, of any court's work, is to take your time, allow the things to sort of settle on the ground, and then actually decide what the facts were and what the law was. And so court observers should always worry that the court is being forced to decide too much, too fast, and that it might make mistakes. That's a great point. The problem here is that the Supreme Court isn't the first court involved in this process. And when you have lower courts making sweeping categorical decisions with their own sort of minimal briefing, the Judge Borsberg order in this case, there wasn't even a written decision. It was the transcript that everybody had to sort of parse for his actual reasoning to understand, well, was the whole part about turning the planes around, was that really part of his decision, or was that just something he spouted off from the bench? You have all the lower courts racing way too fast on this. And and Justice Alito and others saying, come on, let's be realistic here. Let's actually get our hands around what's really happening here and try to impose some order on it. So I wouldn't say it's disingenuous. I'd say each of them is focusing on a different part of the problem for reasons that I'll leave up to you to decide.
That's very, very kind of you. Thank you. Because we're all here just trying to make sense out of a very complicated situation.
But John, let me compare this to something else that happened. Okay, about 10 years ago, what really sent this whole Supreme Court, it's called the shadow docket, the emergency docket, the court really cracking down quickly on lower courts and administrations. Here's the moment that really triggered that. About 15 years ago in the Obama administration, and as you and I keep repeating in my articles and when I'm on the show, this all started with the Obama administration. There was a huge EPA case. The EPA announced sweeping new regulations of power plants, and it went to the Supreme Court on the usual slow, ordinary course of business. And the EPA ends up losing. One of Justice Scalia's last opinions, it would have been 2015, the court says, no, the EPA totally screwed this up. Go back and do it over. And as soon as the court decided the case, the Obama EPA issues a statement saying, well, you win some, you lose some, but the most important thing here is while the case was pending, we forced the entire industry into compliance, and they're not going to undo that. So even though we lost the case, we won the war. And that seemed to be the wake-up moment for a lot of the lower courts and also for the Supreme Court to say, wait a second, the administrative state can move very fast. It can outrun a lot of judicial review. We need to find ways to slow that down. Then a few years later, we went through it over and over again in COVID, where you had Governor Cuomo and others just quickly announcing executive orders, making and unmaking them on the fly, and the courts constantly trying to keep up with that, including the lower court. And in the last few years, progressives have obsessed over the Supreme Court's role in this, denouncing it as the shadow docket. And this is, again, I was on the Supreme Court Commission. I had to listen to a lot of this. People saying the problem here is the Supreme Court. But no, the problem here is an administrative state that can move amazingly fast, district court judges who can move amazingly fast. And we're seeing over 10 years the Supreme Court trying to figure out how to get its hands around that. Again, one last quote for you, John. At the very start of it all, back when Hamilton was debating Madison over the Washington administration and neutrality, there's a great line in there. Hamilton said, presidents have a unique capacity to create an antecedent state of things. Presidents have always had a first mover advantage that changes the facts and circumstances on the ground for both for Congress and courts. That's been there from the beginning, but never quite like this. We've never seen anything like this before. And the Trump administration, as in all things, has taken these trends that have been growing and growing and just exploded them in ways that are forcing a reckoning.
Abe, when we look at the panoply of cases, or the sort of encyclopedia of cases that have risen since the 20th of January, and because of the move fast, break things, do what you can, create facts on the ground, as Adam would say, the Trump version of the administrative state, moving and moving and moving and moving and trying to sort of like bludgeon the liberal culture into submission simply by just constant coming at them. And this then created, I think, conditions in the courts or in liberal jurisprudence as then reflected by the bar looking for the judges that they like and the judges that they like being kind of all interwoven with those lawyers, including Judge Boasberg, who seems to have a daughter who works on immigration issues, which I'm not sure is a reason that he would have to recuse himself. But I wouldn't say it looks good. I wouldn't say that it's like Caesar's wife, that his daughter is basically is an activist, is an immigration activist, and he's ruling on this case, which would have once been something that a judiciary worried about its reputation in that way might have been much more pristine about. But they, once again, what Trump has created, and maybe deservedly so in this case, is a sense of emergency among his opponents that is leading them into places they probably do not want to go, though they don't know that, which is, this is all a crisis. The country is about to become an authoritarian state. We have to stop what's happening using whatever powers we have, at least to slam the brakes on or do something like that. And then maybe sweet reason can be seen, or, like the sweet meteor of death will hit the White House or something. And therefore this can all be stopped. And that just as Trump has created a lot of chaos that might come back to bite him, it seems to me that this legal strategy has weird echoes of the Democrats and liberals going way out on a limb, making claims and making moves that are going to, the anti-Trumps are going to help him. Yeah,
we've always talked about how Trump inspires these anti-Trumps who will sort of rise up to be heroes, in ways that sort of mirror his outside of the bounds approach, right?
Yeah,
and then they end up not getting away with it, and while he does,
or strengthening him, or actually, what they do ends up implicitly making him look better, or at least firming up his resolve and his support or something.
Right. But it also sometimes brings them down.
Yeah.
And now the anti-Trumps are judges. We are seeing that. It's an interesting twist.
I mean, it's an interesting point because Boasberg is a good example. You're pronouncing it differently from the way am I mispronouncing his name, Adam?
Oh, I don't know.
But I don't know. It sounded like maybe there's anyway. What struck me is Judge James Boasberg, who I would not say is like a down the line, based on what I've been reading about him, is not a down the line. He's not some kind of radical consular judge. Like he's thrown terrorists in jail for the rest of their lives. He ruled against Obama on many occasions. Like he's not a rubber stamp for the left. But yeah, this kind of weird glamorization hits almost to me. Oh boy, did he do a fantastic cross-examination of that Justice Department lawyer. I mean, he just walked that lawyer like he was like grilling. He was like a prosecutor. Boy, that was amazing. And then yesterday, the piece, how could he be anything but wonderful? Because Brett Kavanaugh is his friend. And therefore, and he's a nice guy. And Brett Kavanaugh likes him. So shouldn't we all like him? That was an actual 3,000-word piece in the New York Times yesterday or the day before.
Yeah, as opposed to just a few years ago when articles like that read slightly differently. It would be, wow, Judge Eileen Cannon sure is a hack. What a hack judge who keeps ruling in favor of former President Trump, that hack. The judge in Texas, Judge Matthew Kacsmaryk, who heard a lot of cases challenging the Obama administration's financial regulatory policies and so on, issued a number of injunctions or rulings against the administration. And people were so outraged that he issued those decisions and that plaintiffs were able to file cases in front of him, that the American Bar Association actually passed a resolution saying we need to change all the rules about how cases are filed so that Judge Kacsmaryk can't get cases. Now we have,
another example of this. Let me just interrupt you. I saw yesterday there is a story. I just want you to sit down because this is going to just blow you away.
All right.
So apparently one of Eileen Cannon's law clerks is now working at the Justice Department for Deputy Attorney General Todd Blanche. Clearly the fix is in. Because a conservative judge had conservative law clerks who are now working for the conservative administration a year after a case was decided in Florida. Yes, that was decided favorably toward Trump. But I mean, what? That's who do you think they're going to hire?
Yeah. Meanwhile, the way you described the coverage of Judge Boasberg, am I saying it correctly?
Now you say Boasberg. I thought maybe you knew something about the pronunciation, but no. I think it's just your Iowa stubbornness.
Yeah.
And your,
But the coverage reminds me of when you get to the oral argument coverage, and we saw a lot of this with Judge Chutkan in the trial, the 14th Amendment, the insurrection trial of Trump. It's almost like the early coverage of Jen Psaki's press conferences in the first few months of the Biden administration. Remember the Psaki bombs? People said, "Oh wow, she totally owned Ducey or whoever." There is a lot of that. But your larger point, John, about the state of emergency, there's a line just like that in Justice Sotomayor's dissent last night, where she tees up the situation. And again, I think she actually does a pretty good job of the tick-tock around what was happening in the case, what the trial judge was doing, the way the Trump administration was trying to get out ahead of that. She actually does a very good job of spelling that. And that, I think, is what ratcheted up the pressure on the trial judge as much as anything. Justice Sotomayor says, quote, "Recognizing the emergency the government had created by deporting plaintiffs without due process, the district court issued a temporary restraining order that same morning." So it really is there in Justice Sotomayor's narrative of this. The emergency here is not the emergency that Trump declared, the immigration emergency. And I think the facts around that order and a lot of other orders from President Trump are very dubious. But here you have the alternative narrative that actually the emergency here is the emergency of the administration and its actions. And that justifies a very fast pace by trial lawyers and trial courts.
Okay, so now let's move on to what the 9 justices appear to have agreed unanimously to across these dissents and concurrences, right? Which is that due process was somehow likely denied to the people on the plane and the people who are now in El Salvador, or that at a very minimum, they sound like they will look unfavorably on the idea that because they were illegals, or because it was not determined precisely who was legal and who was illegal. Maybe that's an even better way to look at it.
Yeah,
that a due process must be granted in these cases, and that declarations of emergency do not overwhelm the demand for due process. Do I have that correctly?
Yeah, that's right. That's right. Here's the line from the end of the majority opinion. Quote, "For all the rhetoric of the dissents, today's order and per curiam, the decision, confirm that the detainees subject to removal orders under the Alien Enemy Act are entitled to notice and an opportunity to challenge their removal." And they go on to say, "The only question at issue right now is which court to file that in." So the court unanimously, and the dissents reiterate this, Justice Kavanaugh's concurrence reiterates this. The court is, in fact, sort of hearkening back to the Guantanamo cases of the early years of the global war on terror. You have a right to challenge this deportation. You have a right to notice and an opportunity to be heard. And now we'll spell out, we'll see which courts these need to be in and what that actual process actually is going to look like in the courts.
That seems to me to be the most important aspect of what happened yesterday, because it goes to what the administration continues to do, particularly in relation to people on college campuses. And of course, I guess the case particularly of Muhammad Khalil, who is arguing that he was denied although he isn't really being denied due process, because his matter is being taken up by the courts, which have already ruled that he has due process rights. Yeah. But
this is part of the debate, right? Which is everybody saying the term due process and nobody being clear about what they mean by it.
This term due process, I do not think it means what you think it means.
Right. We have we had a Republican congresswoman say, well, if you're going to be part of a gang, you don't get due process or whatever. I'm not sure that people understand, but in these cases, how does the public interpret what they're seeing? As how do we know when someone's getting what is actually due process? How is the public supposed to understand this sort of debate when they see, Mahmoud Khalil, like John said, looks like he's getting his day in court. They're not moving him out of New Jersey. The court ruled, right. It seems like that, but the stories are they're snatching people off the streets and stuff. What is legal here? How do we know what they're doing is okay and not okay?
I just want to add one complication here, which is that in the cases of their being non-citizens too. I mean that's what always throws me here.
Yeah. Well, how can people know? Well, they should read Andy McCarthy, of course. But as of the question of what the due process is, and we should be really careful here, John, because the court's holding is limited to due process under the Alien Enemies Act. So they're not making a sweeping pronouncement about the other cases, including these these campus protesters and so on. This is about the Alien Enemies Act. As the court says, people are entitled to judicial review as to the questions of interpretation and constitutionality of the act. What does the Alien Enemies Act actually empower the president to do, and is it constitutional? And then the factual question under the act and under President Trump's proclamation that this person is in fact or is not an alien enemy 14 years of age or older. So a lot of the due process is defined by the statute or by the proclamation, the factual standard in the proclamation. It's not a sweeping promise of due process to challenge any deportation under other laws or other circumstances.
Fair enough. So that was my illusion, and obviously mistaken, but I don't think mistaken in the broader context, by which I mean that this is the crux or the hinge of the liberal argument that Trump is using authoritarian powers not arrogated to him to make moves on green card holder in the case of Khalil, but of simply people who are here as guests or are here illegally, and that he does not have the power to make unilateral calls about this. And anyway,
and think how much the conservative side of this argument has conceded since the Guantanamo cases, right? 22 years ago, there were huge constitutional fights over whether there should be any judicial review of these things. It was not assumed at all, and Justice Thomas and others were arguing very strongly this was an area of core presidential power where the president could take these people, whether out of the U.S. or out of Afghanistan, and put them in Guantanamo indefinitely. Now you have all 9 justices saying there has to be some kind of process ex ante. Now, they don't answer the or what question. They don't actually answer what happens if, to keep using my Dukes of Hazzard analogy, I won't let it go, those Duke boys actually outrun the heat. And you actually get these people sent down, the Trump administration actually sends these people down to El Salvador or whatever. The court doesn't answer that question of whether the U.S. courts actually have the power to force a president to force El Salvador to release these people. And in fact, the Justice Department's recent briefs have really scoffed at, even mocked the notion that a trial judge could order a president to order a foreign country to release these prisoners. That's a huge question. What the court's trying to do here is try to minimize the circumstances where that actually happens by creating a framework where you can actually adjudicate these cases up front. Well, the majority in this last opinion says at the end, we see no value in delaying these framework questions, these procedural questions about how the trial litigation should work. We don't want to delay that to months from now after the process has begun to play out and we have to restart everything. They're trying to rebuild this from the ground up, just in the same way as last week when they issued an order around DOGE spending cuts and education. They said these kind of cases shouldn't just go to random trial judges. They need to go to the Court of Federal Claims that has a very sort of established procedure for people getting money that the government orders them. They're trying to take these cases out of an emergency posture, regardless of the stakes, and try to put them into the familiar, ordinary workings of trial courts. We'll see if it works or not. I mean, if the administration keeps bulldozing this stuff through faster than courts can review, well, then I'll be curious to see what the court does next and what Chief Justice Roberts and Justice Barrett and others write. But right now, the court's just trying to reset the framework.
It's not a legal point at all. But what I find most interesting or pertinent about the question of whether or not the administration can be forced to ask the Salvadoran government to send back this one prisoner is not whether the administration can be forced to do it. It's why don't they just do it? That is interesting to me. If you made a mistake, if you did this, why would you need your hand forced here? As I say, it's not a legal question.
Okay, so Tricia McLaughlin, the spokesman for the Homeland Security Department, has an answer to that.
That they can't do it somehow?
No, the answer is that while I think the answer is while he may have been taken in error, doesn't mean that he's innocent. In other words, no, but I mean,
it also doesn't mean he's guilty.
No, well, that is that I think is the complicating factor of all of this. If you're going to mass deport 250 people, it's like if you sweep people up on a street in a protest, one of them could be somebody who was just walking by and got trapped in the, between the barricades. And therefore, one of the many reasons we have why due process exists in common law is the idea that, you have to basically, it's habeas, you have to prove that the person that you have in custody is a person who should be in who the state has an interest in keeping in custody, otherwise should not be in custody. The Guantanamo thing in relation to this is particularly interesting because, of course, the issue with Guantanamo was these were people who were taken outside the United States and who were not citizens of the country in which they were detained either.
Mm-hmm.
They were all foreign fighters in Afghanistan that we took prisoner and were stateless, and therefore either we were going to have to figure out where they came from and send them back to the country of origin that they came from, and could not therefore be sure that they would not simply return to the battlefield to attack Americans. They were taken as prisoners of war, but did not have the status or standing of prisoners of war because they weren't part of a standing army that we recognized as being a legitimate sovereign fighting force. And
we
so
made up for it by sending them to the Bahamas.
Right. Yeah. But I mean, this was literally a circumstance without any kind of legal, juridical, international law precedent whatsoever. Here we just have a different case because we're taking people who are on American soil and moving them off American soil. And I think the commonsensical argument for the right is people who are on American soil, we have a right to invite out. Mm-hmm. We're allowed to say go home. And we're allowed to say go home to Muhammad Khalil. He may have a green card. We can't say go home to Adam White because the only place for him to go home to is Iowa. But we can say go home.
Not bad. It's not bad. It's not the Bahamas.
That's right.
Not bad.
But we can say go home to Muhammad Khalil because he is not here. He is, and what's more, he's only as I just edited this morning a brilliant piece by Meir Soloveichik that will be in the May issue of Commentary about the Khalil case. And he makes an incredibly commonsensical point that hadn't even occurred to me, which is that Muhammad Khalil is currently in custody in the United States because he won't simply say, okay, I'll get on a plane and go home. Yeah. If he said, I'm buying a plane ticket and I'm going to go back to Lebanon and my wife is going to come with me when she has the baby and then we're going to live in Lebanon, he would be released from custody in 5 minutes and he would be taken in a nice escort to Kennedy Airport and put on a plane and he could get off the plane, and he could have a press conference, and everything is wonderful. He is only in custody because he says he has a right to stay in the United States. And I think ultimately, by the way, we can go through all this due process nonsense. Not nonsense. It's not, but we can go through this whole process with him over 2 years, and he will end up departing the United States because he does not have a right to be here.
Yeah.
He has a right to work here. He has a right to be married to an American here. But until he is a citizen of the United States, he does not have a fundamental right to live in the United States. That is not a right that we are abrogating by telling him to go home.
Yeah. I mean, how did we get to this point, John? And it didn't just start yesterday, right? We've now had a decade of people being welcomed into the country, and I'm an immigration dove myself, but people being welcomed into the country mostly by executive fiat, things like DACA and DAPA, allowing in and incentivizing the arrival of millions of people, ratcheting up the pressure on the system. Then you have on top of that efforts to loosen the way that asylum works in immigration law, sort of trying to encourage more people to come to the U.S. to stake broader claims to asylum, not that they'd be directly persecuted in their home country, but that they're seeking asylum from horrific political or economic circumstances in their home country in general. For year after year, decade after decade, you've seen all of that ratchet up pressure on the system, and the pressure is all being brought to bear on the judicial system. Even I don't think that this is an emergency, so to speak, and I certainly don't think it's an invasion in the way President Trump says, but it's certainly an extremely difficult issue for this very small part of our system, the judicial system, to try to sort these things out, to do it in a sensible way, and to protect the due process rights of people who are here, because they do have some due process rights, especially when we're going to send them away. And so it didn't just start with this, with this latest emergency or claim of emergency, but the executive branch from one administration to the next has pushed this all to the breaking point. And now we're asking excruciatingly hard questions like, how do you make sure that some random barber in Maryland, or I think that's where he's from, who's not a member of a gang, it seems, most likely, but he is here in the country illegally. What do you do when he gets thrown on a plane that the president is and his team are filling up as fast as they can because they know a court order might come down in a few hours? It's a catastrophic failure of government. And could I add just one last thing? I keep filibustering. Let me draw one more analogy, John, to a piece I wrote for you a few years ago. Right before the Supreme Court got the Dobbs case to overturn Roe v. Wade, you asked me to write a piece about that Texas law, where Texas rewrote its abortion laws to take abortion enforcement basically out of the executive branch and outsource it to trial lawyers, right, to sue over people giving access to abortion. The whole point for that crazy law was that trial judges had found ways to freeze every abortion regulation in red states, freeze it in place during in the Roe v. Wade era. And that fast-moving trial judges totally distorted the system, and the trial lawyers had totally distorted the system, so that Texas ended up having to had to create a law that I think in most ways was crazy and in some sense unconstitutional, but it was all done just to avoid that first layer of judicial review. This is such a huge problem from one administration to the next, the constant collision of fast-moving executive power and fast-moving trial judges, and there's going to have to be a reckoning at some point. And Congress is looking at ways to fix this. I don't know if they will. I think folks are wondering how the Supreme Court's going to fix this problem.
So I used this phrase, I regrettably, 5 minutes ago, where I said the due process nonsense. And I really don't think it's nonsense. I think it is as important a basic element of common law as you could possibly have, due process. And I bring this up only to say that one of the reasons that we have things like due process, or that was it Nancy Mace? I can't remember which Congress was it Anna Sparks? Maybe it was Victoria Sparks, who said, "Yeah, if you're elite, you don't get rights. You don't have due process, whatever. If you're here, we have things like due process because they're unpopular." It's very important to understand that law exists in order to ensure that things that go against the popular will, that are nonetheless necessary for the not only administration of justice, but for the simple good working order of a civil society, are done. And that's why we enshrine them in law at some point when they are a consensus, because at some point later, the consensus is going to break down. And it's going to be, you know what, everybody gets due process except someone who's accused of pedophilia. And that person can be strung up and lynched, because that's too, that's the crime that I don't even care if some people get roped in unjustly. The monstrousness of it gives us some leeway, right? It's like triage. Maybe you kill some of the patients if you're doing triage, but better triage than nothing. And this is what the last 15 years, if we start with Obama, have brought us to, which is that everybody has the thing that they want to suspend our constitutional order to make sure happens. Some of it's right wing, some of it's left wing. Some of it's you got to stop the trial judges with allowing lawsuits, and some of it is whatever on the right, and a lot of it is stuff on the left with environmental regulations or something like that. And this is why we're not supposed to do it this way, because that's the constitutional crisis that there's this whole we're about to be in a constitutional crisis. And the problem is Trump didn't start this. He is moving it in radical ways, or pushing it on 17 different fronts, which makes it seem much more destabilizing. But this is a problem of a world in which the restraints of custom and process and the Constitution, everyone is just now operating without internal restraints. Like I say about Judge Boasberg, who might have said, I can't really hear this case. This is like my daughter's livelihood. And we need to make sure that what people trust, that when our court makes a ruling on this, they can't say, well, the judge's daughter is like practically a plaintiff, or is a lawyer's is a plaintiff's lawyer in these matters. So that's where I'm sorry I said due process nonsense, like quite the opposite.
Well, it is interesting to see, now you mentioned it, put it that way, the mirroring between the way this administration and conservatives are approaching due process and immigration. For progressives, maybe there's an analogy to something like the Me Too movement, right? Where believe all women. There's this huge problem of sexual assault, and so we're gonna always, if we have to err radically on the side of the accuser, not the accused. At the big macro policy level, Trump is announcing, we have a national emergency that requires sweeping changes to trade, right? We're going to change all the trade rules. The analogy might be to the way progressives in the Biden administration and Obama administration approached climate policy, that this is the big thing, the big global problem that requires sweeping change. And if Congress won't act, we will. Just constantly pushing and saying this justifies enormous, quick action. Let everything else fall.
And that gets to my the disingenuous point that I accused the Supreme Court's decisions yesterday of reflecting, because Trump knows perfectly well that there's no emergency in relation to trade. He thinks that there is a systemic problem with trade and the trade deficit that needs to be resolved, but it's not an emergency in the sense that if it's not resolved in 6 weeks, the world is not going to come to an end. That's what an emergency is, right? An emergency is if we don't do X right now, the consequences, immediate consequences, are going to be destructive. And that is simply, so you use the word emergency to trigger certain things in law, right? In the National Security Act of 1952, which is sort of the trigger for a lot of the immigration stuff. The trade stuff is a law from 1977. I don't even really understand what the hell it is. And then, of course, the Alien Enemies Act,
but
which
all this,
most of us thought didn't had been rendered unconstitutional at the end of the 18th century, though we were wrong because it was the Sedition Act that was and the Alien Act wasn't. But I didn't know that. I thought they'd both been found unconstitutional.
This was all turbocharged by COVID. That was the emergency to end all emergencies, and that opened the door to you could declare anything an emergency.
Because that was the emergency that both sides, at least at some point, agreed was an emergency.
Right.
Had different things, to do about, but both sides were like, the emergency is here. And that
the Centers for Disease Control asserting its power over private contract involving the rental of an apartment. Let's just stop for 5 seconds and think about that. That the Centers for Disease Control said you're not allowed to evict someone in Pasquoxy, Alabama. Was I taking Yes, I was taking crazy pills. Abe is absolutely right. You can't believe the kind of things that were asserted. And people did react. And this is where, again, we have this question of whether or not a lot of this stuff is going to be the meat, is going to be the hidden architecture of what happens politically in the United States over the next 10 years, the stuff that people are going to react to. Trump may look at this and say, I have an 80-20 issue here on immigration. He has moved the country on immigration. There's no question. And Democrats are going to move on immigration. If you think the Democratic Party isn't already a more right-wing party than it was on immigration, it isn't going to move further to the right as it approaches 2028, I think you're very much mistaken. The open borders world of the Democratic Party, despite its immense amount of money that flows from those people and politicians who really do believe this stuff, they're not going to withstand this stuff. And Trump moving on 25,000 different fronts to push the barriers of what government can and cannot do, there's going to be a counterreaction, and the counterreaction isn't going to be that positive for the right unless all sorts of other things go right. In other words, like if the economy booms and the trade war, whatever, if the economy booms, then there's a lot. If there's, if like we're safer, we win wars or whatever, there's going to be a lot. But if things don't go particularly well, all this other stuff is going to start leaching into what looks bad.
And John, I just add one last thing as we're sort of seeing how this plays out. For the last 4 years, the Biden administration, the Democratic Party became the party of the buzzword was insurrection, right? January 6th was an insurrection. We need the insurrection justifies throwing Trump off the ballot. We need this unprecedented case in D.C. against Trump, which, while it wasn't technically about insurrection, it was basically about insurrection. The I word for the Democratic Party for the last 4 years has been insurrection. For Republicans, the I word is invasion. Over and over again, we've seen, starting with red state attorneys generals and some lawsuits near the end of the Biden administration, and now with Trump's proclamation and so on, it's invasion, invasion, invasion. And for both of these things, insurrection or invasion, they're sort of get out of checks and balances free cards for the respective parties. The insurrection justifies everything. The invasion justifies everything. Was it really an insurrection? I personally tend to think it came pretty close to it, but that's a question of fact that gets sort of, we breeze past. Is this really an invasion? Well, President announced that it was. Is it really an invasion? Well, don't know. We invoke these words like talisman because they unlock either legally or just politically sort of enormous constitutional discretion by our preferred policymakers. And it's not I don't think it's going to end anytime soon. I think we'll be back talking about insurrection 4 years from now, one way or another.
And we add the rogue judges stuff to it, right? Yeah. The Democrats were talking about rogue judges, and now Republicans talking about rogue judges, which is a sign that it's not.
They stole
the
that.
idea that even the judges
Democrats
can stop that.
Rogue judges is a 60-year issue on the right, 65-year issue on the right. Not an issue. It's the left now finally has a couple of rogue judges that they can have. They're having fits about. But this was a major issue for the right from the 1960s onward, the sort of the liberalization of law, basically benefiting, turning things toward the benefits of the accused and toward criminals rather than to the victims of crime, and to the sort of good working order of a civil society. And they may think that they're going to get the rogue judges, but they don't get the rogue judges, because every time they look like they're going to move positively on rogue judges, you get this like judge in New Hampshire saying, "Hey, I'm a judge in New Hampshire. No one in the country can do anything. I have spoken."
But John, maybe to bastardize Abe's timeless line,
Yes.
It's better than that. It's better than that.
Oh,
you know,
good.
when I that's the Iowa version of it's worse than that. It's better than that. When I look around at what I'm seeing right now, and I'm seeing suddenly Democrats and progressives are very, very, worried about too much power in the administrative state. We have a president, not a king. There needs to be some law and order around this. Presidents can't just make up their own facts, make up their own laws. We need more due process around administration. And in fact, raising questions about whether Congress has violated the Constitution by delegating too much power to the executive branch. There's an opportunity here for conservatives who focus on these issues, the C. Boyd and Grays among us, to say, oh, okay, we're always accepting converts. And if you want to talk now about the excesses of the administrative state and why the Supreme Court needs to do more to tighten up what happens at places like DHS and elsewhere, we should welcome that. I think it's great that the New Civil Liberties Alliance filed a non-delegation lawsuit against the president over the emergency tariffs statute. Like, this is a great time to take those principles and say this isn't just a Roberts Court versus Biden administration thing. It's a rule of law versus all administrations thing, and I hope we see more of those.
You're bringing, just on the verge of Passover, you're bringing that positive Goyish energy here to the Commentary Podcast, Adam, bringing us the spirit of the covered bridges and the glories of the disaster, of dealing with the disaster that is a pool table in our fine River City community. And I think it's very important that you have brought this home to us with your homespun wisdom. I don't know why it so amuses me that you're from Iowa, because of course, James T. Kirk is also from Iowa, and nobody ever made fun of him.
From Riverside, Iowa. I've been to Trek Fest. I know how this goes.
Okay.
And John, I'll be your Midwestern upbeat goy anytime.
Thank you so much. And you as always, a pleasure to have you. We'll be back tomorrow for Seth and Abe. I'm John Podhoretz. Keep the candle burning.